And welcome to the show. My name is Fazlaw. Most people don't know what to do or expect when faced with a legal issue, be it in labor law, matrimonial law, debt counseling, property law, or more. We aim to give our viewers a broader understanding of the law in South Africa to ensure that the vulnerable are not taken advantage of. In this show, we address specific questions aimed to you as the viewers to ensure that you are answered, and these questions are sent to us via our platform, such as the email address and the WhatsApp number that will be provided at the end of the show. Don't forget to send us your questions so that we can make sure that your questions are answered. I'm your host, Fazlaw, and thank you for watching. Today's episode, unfair dismissal. Unfair dismissal is the termination of an employment without cause or without following the fair procedure, or even both. The principles of fairness is unique to labor law. In other words, it's not applied in other areas of law, in the law of contracts, such as that, and also property finance. These other legal fields, they apply the principle of lawfulness. So in this episode, we address what happens to the employee and the employee, the roles of them in terms of the Labor Relations Act and the Basic Conditions of Employment Act. It provides the viewers today with what their rights are and how to enforce these rights, be they an employee or an employer. With me today, we have Advocate Fazlaw Rodriguez, who is a specialist in labor law and is more particularly a specialist in sexual harassment cases and forensics investigations. Advocate Rodriguez, thank you for being on my show again.
Welcome.
So with unfair dismissal, the principle, we said that principle, or let me rather say the termination of employment consists of two things. It has to be fair, and there also need to be a proper substance, in other words, good cause. And so that principle of fairness is, as I said earlier, it's unique to labor law. Can you explain that principle for me, and why is it not applicable to other laws?
Okay. The first thing that you need to realize, in labor law, we deal with fairness. Whereas in other laws, you deal with the law, whether it's lawful or unlawful. So in terms of your Bill of Rights in the Constitution, it speaks of fair labor practices. Now, fair labor practices goes both ways, from the employer side and the employee side. Now, if you will allow me to just start off with a principle.
Sure.
You'll have two tools available, one to the employer and one to the employee. When the employer is not happy with your conduct, in order to correct your conduct, he will apply disciplinary measures.
Yeah.
So it's important for the employer to realize that you apply disciplinary measures to correct behavior and not to dismiss only. If the employee is not happy with the conduct of the employer, he's got a right to lodge a grievance. So that is the two tools. The one is discipline, the other one is the grievance process. Now you will see, if you do go to CCMA, for example, as an employee with an unfair labor practice, they will ask you, have you followed the internal processes, which is the grievance process. That starts in unfair labor practice. With a dismissal, in terms of misconduct, it starts off with a disciplinary inquiry. Right now, with a disciplinary inquiry, you have different types of dismissals, first and foremost. You have a dismissal where you need to correct an employee's behavior. And that is where we will deal with a disciplinary hearing. And in terms of the hearing, coming to the principles that you are referring to, there's two basic principles that need to apply in a disciplinary inquiry. First and foremost, the procedure followed in terms of a disciplinary inquiry must be a fair procedure.
Sure.
Which means that the employee's got certain rights when entering into a disciplinary inquiry. He needs to be notified timeously. He needs to be notified the reasons why he's being called into a disciplinary hearing.
Right.
And other processes that needs to be followed. If the employer is a big institution, there's a formal process that follows, which entitles the employee to call witnesses to present his case at this hearing.
Sure. But
Now, that's the first principle. The
Yep.
second principle is the substantive fairness. The substantive fairness meaning whether the merits require the employer to dismiss that employee. So that's the two principles, the fundamental principles that you deal with in terms of a disciplinary hearing that eventually results in a dismissal.
Okay, thank you. So there's a general assumption that the employer is inherently, in other words, there's that assumption that the employer is strongly or is in a very strong position when it comes to the relationship. Why is that? And what does that refer to really when it comes to the relationship?
At the end of the day, in the past, prior to the Constitution, the employer was in a very strong position because he could hire and fire at will. With the creation of the Constitution, it deals with fair labor practices. Now, you must remember that an employer in the private sector deals with profit and loss, and it's his business. So if you are not being effective as an employee in terms of his profits, then obviously he can deal with you in that manner. So there you will have that vertical relationship between the employee and employee. However, the Labor Relations Act that was created stemming from the Bill of Rights creates an equal platform where the employee's rights are protected in terms of the Labor Relations Act, if that answers your question.
Yeah, it does. Thank you. With regards to misconduct, what are the requirements for the employer to prove misconduct? And also, what type of proof should be provided in order to confirm?
Well, let me say a recent case, the Zadumal case, made clear distinctions what is required to determine whether a dismissal was fair or not. So the first thing that you as an employer need to establish is whether there was a workplace rule, whether the workplace rule was reasonable given the circumstances, and whether the employer has transgressed that workplace rule. So those would be the reasons fundamentally that the employer can take action against the employee because he was in breach of a workplace rule. Now, a workplace rule can be contained in a policy,
Sure.
or it's a mere standard. For example, your fiduciary duties dealing with
So
loyalty.
can we wrap up
Yeah.
on that one quickly? Just in short, by misconduct, the requirements, if you can just...
It deals with the behavior
Yeah.
and where the employee breaches the workplace rule.
Okay.
That is what will create a disciplinary inquiry.
Sure. We'll continue the discussion after the break. Viewers, we've come to the break, and that is the end of the first segment. We'll definitely see you after the break. Thank you for watching. Welcome back to the show. In the first segment, if you just joined us, we had an introduction to our guest, Advocate Fazlaw Rodriguez. We also looked at the principle of fairness in labor law and the assumption that there's a very strong position where the employer is concerned, but that has now been debunked, and because of our constitution and the various labor law legislation that came into play after the democratic dispensation came into power, our employees are much more protected when it comes to those issues. And we briefly discussed on misconduct, so keep watching the show. And I have with me Advocate Fazlaw Rodriguez. Advocate, can we continue that conversation on misconduct? But I think that we've answered it ultimately. We just want to switch over to negligence. Can you perhaps look at, or for the benefit of our viewers, look at the question of what is negligence and with regards to misconduct, and then also what would be the requirements to prove negligence, and also the sanctions that goes with regards to if proven.
You must remember there's a very faint line between negligence and where the employee is incompetent in dealing with the standard required by the employer. Now, if the employer has established that the employee has met the standard previously, but based on his negligence, he breached a workplace rule. So in order for the employer to prove that, there's the reasonable person's test that he needs to prove. Meaning, would a person, given the position that that employee was in, had acted the way the employee had acted? Right. Now, if the answer is no, that's the first leg of negligence. Then it will ask you, did he take the necessary steps to avoid that negligence? Now, there's 3 or 4 requirements that is needed for the employer to prove negligence. Now, negligence per se, it's not a dismissible transgression. However, if the employee's negligence result in a possible loss to the employer, financially or otherwise, then that negligence becomes gross negligence. And if the employer proves the requirements of negligence and he proved that he had lost financially or otherwise, then he can dismiss that employee.
And then with regards to sanctions, would be obviously then just a dismissal, or if it's not gross, then it would be
Depends, because as I've
a
indicated,
fine or a warning,
yes,
or
as I indicated to you at the very beginning, the purpose for taking disciplinary action is to correct that employee's behavior.
Right.
So in order to correct the behavior, you can either go into a counseling, written warning, final written warning, or even a demotion.
Okay. With regards to unfair dismissal, who has the onus to prove that the employee has been now unfairly dismissed?
There's a provision in the Labor Relations Act that says for dismissals, the employer's got an onus to prove that the employee has committed misconduct in terms of having breached a workplace rule. Okay. So the onus always rests with the employer at the disciplinary hearing, so too at your CCMA or bargaining council, if there is an agreement that there was a dismissal.
So ultimately, the employee would make an allegation or submit to the CCMA a referral form, and that would be that I claim that I've been unfairly dismissed, and then the employee would have to come to the CCMA and prove that he was fairly dismissed.
Yeah. What happens in a case like that, the employee obviously does the referral to the CCMA or to a bargaining council if he falls under the auspices of the bargaining council. Employee.
Yeah.
So the employer then say he was unfairly dismissed.
Yeah.
Now, as I've earlier now indicated, if there's an agreement that there was no resignation and that he was an employee and he was dismissed, then the onus falls on the employer to prove that the dismissal was procedurally and substantively fair.
Understood. Next question. Now, with regards to procedural fairness, and just to follow from the act of misconduct, not, for example, assault or theft, what would be a fair procedure to follow with regards to that type of allegation?
Well, basically, the employer will conduct an investigation, which is a preliminary investigation to see, for example, if there was theft.
Okay.
Now, if this has been established that there was theft and that employee is responsible for the theft, the employer then will serve him with a notice to say you need to attend a disciplinary hearing on such and such a date. And in the notice, he will indicate precisely exactly why the employee is being charged, so that he can answer to the allegations made at the disciplinary hearing.
Okay, thank you. What would be the appropriate sanctions, again, just to make sure that we understand that for some allegations of misconduct, the sanctions are generally the same. It would be a warning, verbal warning, written warning, final warning, or dismissal. Is that correct?
Correct.
Okay. And then with regards to a disciplinary hearing, who can be the chairperson? Would it be someone within the company, or would it be best to be someone outside that's neutral? And then also, what type of evidence, or who should be the person to consider the evidence that has been presented?
Basically, if it's a big company, then you will have a formal process.
Okay.
Now, the employer's got a right to appoint a chairperson. So he can appoint a person from within the institution to chair the disciplinary hearing, or he can appoint somebody outside with the necessary skills and knowledge to chair disciplinary hearing on the basis that the chairperson is perceived to be an objective person,
Yeah.
not knowing the contents and merits of the transgression.
Yeah.
So that basically allows the employer to determine who will chair the disciplinary hearing.
Okay, perfect. And then with regards to our last question before we go for another ad break, the type of evidence that can or cannot be used during a disciplinary hearing.
Basically, you must know a disciplinary hearing, it's a very informal process. So basically, people will use hearsay evidence, which come across on many occasions in a disciplinary hearing. But that doesn't automatically exclude that evidence from being presented. The chairperson has got a right to listen to the hearsay evidence, and in his conclusion, making a determination in terms of his findings, he then attaches the weight to that evidence.
Thank you, Advocate. That brings us to another ad break, viewers. And please keep watching so that you can get your answers to your questions. And I'll see you after the break. And welcome back again to the show. If you've just joined us, we are in our third segment. The second segment, we had a just short recap of the first segment. And in our second segment, we discussed the aspects of gross negligence. We also looked at the onus of proof, who have to provide the proof and confirm that the employee is in fact guilty of whatever allegation. And then also we looked at the fair procedure in a disciplinary hearing, be it within the company or at the CCMA. And we also discussed the sanctions that could be applicable. And then finally, after towards the end of the second segment, we looked at who and what the role of the chairperson would be in a disciplinary process. So yes, keep on watching. And with us today, we have Advocate Fazlaw Rodriguez. Fazlaw, let's continue the conversation. And in this particular segment, I'd like to deal with the aspects of substantial fairness. So we're quite comfortable that our viewers benefited from your explanation in terms of the procedural fairness. Let us look at the substantial fairness and what does that really mean?
Okay, basically, substantive fairness deals with the evidence, the merits of the case, right? So if there's an allegation, for example, and we need to just come onto this point, that, for example, you've stolen from the employer. The employer will have to prove that you've stolen from the employer, what it is that you've stolen, and what effect it had on the employer's relationship with that employee. So that would be your substantive fairness. Now, just to add to what we said in our first and second segments with regards to the sanctions, when an employee is found guilty of dishonesty, then you can be dismissed, even if it's the very first transgression. The question you would ask, why? Because the relationship had become intolerable. I cannot no longer trust that employee in my institution.
Sure.
So that is one of the provisions provided for in the Labor Relations Act, where it says neither a court nor a decision maker can reinstate an employee or re-employ an employee if it's proven that the relationship had become intolerable. Now, dishonesty is one of those transgressions that makes the relationship intolerable.
Thank you. With regards to the test used to determine substantial fairness, what is that test?
So basically, the burden of proof is on the employer, on the balance of probabilities. The probabilities would mean he probably are guilty of that transgression.
Sure.
So basically what we use is a 50-50 plus 1 type of test in terms of weighing the probabilities.
So just to give a bit more definition to that, what you're saying is that in criminal law, there is a the tests or the burden of proof should be beyond reasonable doubt, right? Whereas with this is more civil process and it's on a balance of probabilities. But I think it's even less than what you would find in civil court. Am I
Yes.
correct?
Look, it's much less on the basis that if the employer proved to a certain extent the evidence presented at the disciplinary hearing or at an arbitration, the arbitrator sits back and he then weighs up the evidence. And when he weighs up the evidence, he has, like I said, the 50-50, 51%. And in his mind, if you feel that the employer was guilty based on what was presented to him, then he can find that the employee is guilty of that transgression.
Sure.
Yeah.
And just to make sure that that particular chairperson would then make a recommendation to the employer of these findings, and the employer would still make a decision and take the recommendation or even say, no, it's fine, thank you, I've looked at your recommendation. If the recommendation says dismissal, the employer would still have a choice not to dismiss. Is that correct?
Just to clarify where that is concerned.
Yeah.
For example, in the public sector. Public sector deals with collective agreements. So the disciplinary code and procedure says that the chairperson will pronounce the outcome, meaning the chairperson now say you are dismissed.
Okay.
Now, once the chairperson say you are dismissed, now that deals with your public sector. But then in your Educators Act, it deals with a recommendation. So it all depends on what the disciplinary code and procedure says. If it gives the chairperson the powers to pronounce a dismissal, then you're dismissed.
So just in short, what is the workplace rule and how do you now look at, what type of evidence would be required to prove that the person has contravened that workplace rule? In short, summary.
Basically, a workplace rule is contained in your policies. The employer's policy saying late coming, for example. He's got a policy say that you must report for duty at a specific period of time. If you fail to report for duty at that time, you are in breach of that leave policy, for example. So that's a sort of example.
Thank you. Now I need to look at what is the process at the CCMA.
Yeah.
We've got, we are limited in time, so if you could maybe just take us through the steps, but not just summary. First step, what would be that you would have?
The very first step, if an employee has been dismissed, he will then do a referral, which is called the Form 711, where he requests for conciliation. So then the CCMA or the bargaining council has got 30 days to set down that matter for conciliation. Now the conciliation is type of a mediation process, where the conciliator sits and he tries and resolve the issues between the two parties. If he cannot resolve the issues, he then issues both parties with a non-resolution certificate. And with that certificate, the employee's now got a choice either to proceed, and then he will do a Form 713, which is actually a request for arbitration. Now, the CCMA or the Bargaining Council has another 30 days to set that matter down for arbitration. Now, your arbitration, it's a de novo hearing, meaning a new hearing, where the arbitrator hears afresh the evidence that was presented at the disciplinary hearing, or if there's new evidence that the employee or an employer wants to present, it's presented at the arbitration. So that means to say the arbitrator looks at the substance of the evidence presented, but he also considers the defects in the procedure that took place at the disciplinary hearing.
Then finally, the last question, what are the potential outcomes with related to an unfair dismissal case in terms of compensation?
Well, the Labour Relations Act speaks of a decision maker, which is your arbitrator in the case of a unfair dismissal dispute to the CCMA or bargaining council, can only compensate an employee up to a maximum of 12 months, equal to his salary. So he cannot give more than that. So if you were earning 100,000 per annum, he can only give you compensation equal to 100,000 rand per annum, or anything less.
Thank you. Advocate, that brings us to the end of the question and answer sessions. You've been a great guest, and we're looking forward to seeing you back again in the future.
You're welcome.
Thank you. Well, viewers, that brings us to the end of the show. And before you leave, do not forget to send in your questions via the platform. Our email is info@fazlaw.co.za and our WhatsApp number on 082 49589. Our next episode, we discuss what can you expect from your local councillors. So please follow us on YouTube, Facebook, Twitter, and Instagram. And thank you for watching our show. I'm your host, Fazlaw Abrams. Thank you.